Hey, welcome, my little Tattle Tells. Listen, y'all know I got her early because, listen, Wendy Williams. This actually isn't a laughing matter because this is actually really serious. But I got my jokes no matter what. Thank you for you guys for joining me for what's going on with the Wendy Williams situation. There's been a lot of speculation and there's been a lot of gossip going on. I know you guys are like, Tisa, you're the main gossiper. This is true, right? But at least instead of watching other people's videos and getting my information from there, I went straight to the source. Now, let me start off by saying I was minding my business, watching Korean dramas. I know I found one. I don't even know what it's called, but I accidentally clicked on it on Netflix and I'm addicted to it. I was eating my dragon fruit. I was minding my business. And BuzzWorthyTv, that's BuzzWorthyTV on YouTube. There's a link in my description box. BuzzWorthyTV actually broke this story a while back. They inboxed me and told me to get over to Choke No Jokes Live. By the time I got there, the live had ended. However, it's still up on his page. There is a link to that live too. He was talking about the Wendy Williams situation. BuzzWorthyTV was also talking about the Wendy Williams situation. Now, Choke No Joke, right? And I don't know him. But he showed the documents, but he didn't actually show the full documents, so I could take a screenshot and be like, oh, I cited my sources. It's Choke No Joke. And then capitalize off of his work. Choke was like, it's public record. Go find it yourself. BuzzWorthyTV hooked me up and gave me the records. That's why I wanted to actually read through the court records, the court transcripts, the court documents, whatever you want to call them, and actually share them with you guys so we can actually get to the truth. Okay. So again, y'all know, there's nothing wrong with watching other TV bloggers. I misspoke. I watch other people's videos all the time, but instead of sitting there and just listening to what somebody else says and then reporting like I know what's going on, why don't I actually read the documents, share them with you, and then we can actually get to the meat of what's going on. However, BuzzWorthyTV and Choke No Joke are offering also continued coverage, and BuzzWorthyTV is going to keep following this. We need the judge to rule, and Choke No Joke hinted at, right? I don't know if it's confirmed, but he hinted at that he's going to try to do a sit down with Wendy Williams, with Wendy Williams. If that happens, I'm recapping that mess, right? But let's go and support the people that actually gave. The links are in the bio. Okay, the first thing that I want to clear up is I don't know where everybody's gotten it from. And again, Choke No Joke and BuzzWorthyTV did not say this, but I don't know where it's coming from. Wendy, the assets were not frozen. The bank never said they found Wendy Williams incompetent. This is part of the lawsuit why they're suing the bank. They never said that they found Wendy Williams incompetent. It's funny how people have this, and again, take it for what you will. It's funny the way this rumor started that Wendy Williams has dementia. And the people that are spreading this rumor around are doubling down on it and using this as proof. Ooh, she must have dementia. It's not true. Part of the lawsuit is you have no proof that she's mentally incapacitated, but there was different factors for which they could freeze an account. They did not provide proof of any of them. It could be mismanagement of funds. It could be negligence. It could be ada. We're going to go into it. The bank didn't provide any of that proof. And what's more, they overstepped their bounds. There's something funny going on. You know what I'm saying? I smell a scam, right? I smell a scam. And for y'all to think that banks aren't above scamming, now I'm not saying Wells Fargo is scamming. I don't want to go to court with Wells Fargo, but I'm saying there's something that's off, something that's fishy, and they're 100% overstepping their bounds, especially if Choke No Joke can be, his sources can be relied on that Wendy Williams' son is actually a power of attorney. We're going to go into a power of attorney. We're going to go into the documents. I have them queued up. Hey, what's up, House of Glam? How you doing? Hey, Andrew. Is Choke a Joke a full-time YouTuber? I don't know, but he broke this story, so I don't know. But he was doing this thing on this one. And also BuzzWorthyTV. Let me just cue everything up so we can get started. And then let's get into this. Y'all ready to get into the mess? I know I am. All right. So 1 second, guys. Let me just cue everything up. And then we'll go. How's everybody doing tonight? I'll try to put timestamps for when this starts. It's starting on 1 second. If you are joining on the playback, but we're about to jump into this. You know the way my lives are. We pretty much jump into everything right from the beginning. Right from the beginning. And I'm usually on time too. Shut up, Tattle Tells. I know what y'all are like, sounds good, Tisa. I am. All right. So we're going to try to see if we can get legal analysis to actually join us. If not, that is quite all right, because this case is pretty straightforward. For those of you guys that don't know anything about legal jargon, it's okay, because this is what we need to do. Hold on, guys. Okay. All right, we're all queued up and we're ready to go. What's up, my little TisaTells in the thing? I'll say hi to you guys later. Let me just get started. Let's see. Mocha Mina said Chronicle Speaks read the complaint. Okay. That's great. Thank you, Mocha. We're going through the court docs, but thank you for pointing that out, Mocha Mima. I'm just crediting the people that bought the story to me. If you guys don't mind, is that something we can do? Or do you guys have objections with that? Should I just shout them out and not link them because I don't really want them to get the views? Their links are in the description box. When this live is over, I'll also have it in the comment section as the first pinned comment. So you guys can also follow various things, because I do believe YouTube, listen, it's like TV. Just because you like ABC does not mean you're never going to watch Fox. Just because you like Fox doesn't mean, again, just because you're giving other people's views does not mean that I'm not going to get my views. So I want to make sure that the people that bought me the story literally gets my views. Okay, there we go. And of course, if Chronicles Speak read the court papers, fine, but I'm crediting the people that bought me the story. Okay, and are covered it themselves, but they were nice enough to share the story with me. Okay. Hey, LA, what's up? What's up, Nerva? Hey, everybody. Okay, let's get into this. Y'all ready? Y'all ready for this? Okay. So here we have, right? It is a complaint between Wendy Hunter. We know this is legit because Wendy's full name is Wendy Dawn Hunter. She signed a petition, I believe, back in 2012 that was granted by the court to remove her middle name and to also make her legal to remove her middle name to Wendy Hunter instead of Wendy Williams. So Wendy Williams is a professional name, Wendy Hunter. This is against Wells Fargo Clearing Services, LLC, and Wells Fargo Advisors. It's very, very important we know that this is against Wells Fargo's advisors. If you guys don't know, a lot of people have been speculating on what a wealth advisor does, right? Yes, EHC Bunny, choke no joke, was the same person who uncovered Portia's secret relationship with a Real Housewife. Oh, I don't know if he uncovered it, but yeah. You guys, okay, at Chronicles speaks into that. Yes, we love Chronicles things, but this isn't, you guys stop it. Okay, on my channel, we don't shade other people. What I say, I mean, I'm giving credit where credit's due. You guys can just stop it right there. Okay, so here we go. So I need to go before we go into this what advisory services are. Advisory services, they provide the following benefits: advice on security selection and portfolio construction, exposure to class assets that can potentially offset the ups and downs of market volatility, professional money management teams to oversee your investment selection and perform ongoing portfolio monitoring, and predictable costs based on asset level. Wells Fargo advisors are committed to providing you choices in how you do business with us. We offer a broad range of advisory programs designed to suit the level of involvement you prefer in the day-to-day management of your investments. It's important to know that this person is only in charge of monitoring the portfolio and making sure that her level of risk never grows out of the level of risk. You know, when you sign up for like your 401k or whatever, they're like, what risk do you want? Do you want low? Do you know, which is like government bonds? Do you want medium, which is kind of like, you know, private equity fund of funds, right? Or do you want high risk, which is more volatile stocks? They literally, that's all they're supposed to do. They monitor. They cannot make a move without your consent. They cannot make a move without your say so. They are not a bank teller that monitors your private assets to the point of they monitor your spending. That's not what to do. Okay. Listen. Yes. Advisors don't control. Listen. Yeah. They deal with your money. But again, how can I say this? Wealth advisors in the bank are basically salespeople. They provide a service, which is to talk clients into investing in financial vehicles that the bank either has a part of or the bank would like you to invest in. They literally are salespeople. You don't need to do it with the bank. You could go outside. You can go to Morgan Stanley and be like, yo, manage my wealth. The bank tries to keep everything in house because the more money you have with the bank, the more the money the bank can leverage your money. If you guys don't know, the Security and Exchange Commissions has a base level that for every dollar you loan, a bank loans, it must have a certain amount of dollars underneath. So if a bank literally leverages or loans or even shorts or longs on the stock market, let's just say $1 million, the SEC will say, the Security and Exchange Commissions will say, okay, for every million, you maybe have to have 100,000 actual cash in the bank. That's to make sure that if the loan goes belly up, right? Or if the short goes belly up, there will be some type of at least money in the bank to pay the customers, if that makes any sense. When I say pay the customers, you know, when you sign up for each bank account, every bank account, I believe, insures you up to $250,000. So if our economy completely falls, if the bank goes bankrupt, you are guaranteed that you will be paid 250,000 US dollars for every bank account you have. This is another reason why wealthy people have multiple bank accounts, because if one bank account goes belly up, it doesn't matter what he had, 10 million, 1 million, or 250,000. They're only insuring you up to 250,000. They're guaranteeing they have 250,000 no matter what to pay you. Okay, let's not get too bogged down in this, but that's what's going on, right? That's what's going on. All right, so let's read the petition. Let's go through this and then we can talk, right? Now, Wendy Williams is the one bringing this petition. This petition is for an emergency petition for preliminary injunction, temporary restraining order, and other relief in aid of pending arbitration. Why is this an emergency injunction? Because they are trying to say, because all of her assets are frozen to the point of she can't even see what her account balance is. They can't listen. Wells Fargo does have a history of condoning BS. I agree. But to the point of she cannot even see what money she has. She cannot even check her online balance. She is complete in the dark of what is happening in her assets. This is an emergency because she is saying she has no way to touch her funds. This happened 2 weeks ago. She has no way to touch her funds. She has no way of even seeing money. She doesn't even know if somebody's stealing from her. She doesn't know what's going on with her money. They're saying it's untenable. She cannot function like that. It is untenable. So they're asking for a preliminary injunction. An injunction is something you do to stop someone from doing something. A restraining order is to stop somebody from doing something. An injunction is something you do in the middle of a court proceeding. You want an injunction. So it's basically like a judicial order within a judicial order. It's basically saying, okay, fine, she can have access to her funds, but we're still going to try whatever issue Wells Fargo has. Do you see what I'm saying? Okay. Now we're on the same page. Okay. Now, here we go. This brings a special pursuit of Article 4, the civil rules of procedures, right? It's pursuant to Article 63 of the civil rules, the civil practice laws and rules. I call them the civil rules of procedure. It's the same thing. One's federal, one's state. This is obviously state. Now, they have to list the respondent, any of their agents, members, officers, employees, representatives, and anyone acting on the respondent's behalf from freezing all of the petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts. Deferred compensations, I'm assuming, are retirement funds, but you never know. Wendy Williams is a rich person. She might have some of her compensation actually wrapped up in stocks that she has agreed not to touch for 5, 10, 15, 20 years. Again, that will be under her employment contract. Now, And they don't want them interfering with her rights to access her financial assets and statements, pending a final binding decision by an arbiter. And they allege the following. Now, let's get into this mess. They allege the following. Let me just get Andrew. Thank you so much, Andrew. Let me just get this off the stream. Okay. They allege the following. Petition Wendy Hunter is an individual residing in New York, New York. This is correct. Upon information and belief, respondent is a foreign limited liability company. All right, Wendy, come through with those offshore companies, y'all. If y'all know about offshore companies, you better get yourself one. A foreign limited liability company operating and existing under the laws of the state of New York. If you guys don't know, when you have a foreign offshore account, if you are going by the codes of the U.S. and they are operating on U.S. soil, they need some type of company that is registered in the U.S. in order to do business. That's why when you see someone and they have all these, they claim to have all these assets, but there's no businesses registered in their name in the U.S. And people are like, so what? You don't know if he has money overseas or she has money in like Timbuktu. Fine. But if they're doing business in the U.S., they need a company also registered in the U.S. in which they may do business. So right off the bat in, Article 2, they're literally telling them they're compliant with IRS. So it's not a scam, right? We're official. Let's get right into this a little bit more. Let's just move this along, guys. Okay. So the court has jurisdiction pursuant to New York civil procedure law rules because all the times material hetero respondently has consistently engaged in, operated, and conducted their business within the state of New York. This is very important because a lot of people do forum shopping. Forum shopping is, let's just say I'm going to sue Andrew, right? Andrew, I'm sorry to put you in the name, but let's just say I'm going to sue Andrew. What happens is, right? What happens is my suit, I might have more favorable laws in California. However, Andrew does business in Pennsylvania. I do business in New York. I just can't pick California laws because I literally need to prove that the place I want it, which is the forum, I have legitimate ties to. As a business, an LLC, we know from Hobby Lobby, right? We know from Hobby Lobby that corporations are considered as individuals. So where your corporation or LLC either does business or has an actual physical headquarter are the two forms you can use. Usually with businesses, it might be Delaware because they have the best, from what I hear, corporate laws, and another state. So you have those choice between two forms. Wendy Williams is not playing games. They're saying we continuously engaged in, operated, and conducted our business within the state of New York. Okay, this goes into forum shopping. They go into Article 4. Venue is proper in this county pursuant to New York civil procedure because respondents' determination to freeze petitioner's accounts and to interfere with her financial assets along with material events also took place in the judicial district of which New York County exists. This was actually very important for them to do too. I just want to take you guys through this because, this stuff's interesting to me. The reason they had to do this, you might be like, okay, but they already established that they have the right to sue in New York because this is where they do business. However, the person, right, the respondent, which is the petitioner is the plaintiff, the respondent is the defendant. The defendant has a right to say, you do business in New York. However, I live in Timbuktu. So not Timbuktu, it can't be out of the country, right? But you do business in New York. I do business in Florida. So you know what? I want this in Florida laws because usually wherever business chooses to do business or is incorporated in or has their corporation headquarters, usually they pick that state because for whatever their business is, that is the best laws for them. However, you can get around that by actually pointing out that the person you're suing also does business in that state. If you can choose that your farm is proper and the person you're suing also has ties to that state, then it's pretty much guaranteed that they will be locked in. Right now, they are trying to lock them into New York state law. All right, there we go. Now, let's move on. Listen, Let's see. Okay. Ugh. Let's see. Hey, Rim, thank you so much. Well, here's the thing. If people are saying, can Wendy Williams pay her rent now? Might be why they're moving for the emergency injunction. Now, Choke No Joke did say, and I listened to his live, he said that Wendy only has one credit card. He only has one credit card. She only has one credit card, and that credit card is an Amex. So it has unlimited as long as you pay it at the end of the month. However, if her rental building or her condo or her mortgage does not, whatever the case may be, does not take credit card payments, no, she effectively can't. Everything is frozen. She can't even get her account balance. This is actually really serious. This is like someone leaving you penniless on the road and being like, all right. And you're like, why'd you do that? And they're like, just cause. That's what's going on. Okay. So here we go, right? Here we go. All right. So venue is also proper in the county because at least one of the participants resides in or is doing business within the New York County. All right, well, just going over that again. All right, so they locked them into forum. Moving on to facts common to all calls to action. On or about April 11, 2018, petitioner and respondent enter into an asset advisor agreement and a client agreement, collectively known as the agreement. Upon information and belief, the purpose of the agreements is for Wells Fargo to provide brokerage cash services and to execute security trades with petitioners' accounts. This is very important. They pointed that out because they are accusing them of over even stepping their bounds. That's it. They want brokerage cash services and to execute securities. Securities are stocks, bonds, trades within the petitioner's accounts. Upon information and belief, respondent is in possession of several $1 million worth of funds which belong to petitioner and are currently managed by Wells Fargo and are held in Wells Fargo's possession. Now, the reason why they used something so broad as millions is because as they actually accuse later in the petition, they can't even see Wendy's actual account balance. So they have no idea the exact amount, but they can say that it's roundabout in the millions. All right, we're getting to the meat. We're getting to the juice. Let's go. All right, now let's go on to the facts common in the cause of action. Article 9. For more than 2 weeks, respondent has denied petitioner any access. Okay, for more than 2 weeks, Wells Fargo has denied Wendy any access, whether online or otherwise, to her financial accounts, assets, and statements based on the advisement by Wendy's former financial advisor, Lori Schiller. She will be referred to as Lori, right? That Wendy was of unsound mind. Now, get this, right? Wells Fargo is standing by Lori upon further investigation, and maybe they're even going to go a court injunction. Banks, Citibanks, Wells Fargo, this isn't the first time I've heard about them doing something like this. However, Lori is saying that she thought Wendy was unsound mind. And this calls into question, Lori, how would you know? How would you know? And this is what the family's saying. But Wells Fargo has not actually, because they haven't issued the response. So even though Lori said that she was unsound mind, in Wells Fargo's response, would they need to actually make a response? I'm going to watch the dockets closely for that. In Wells Fargo's response is where they will either admit, right? They will deny, right? Or they will admit, deny, and if they deny, they will give an affirmative defense. An affirmative defense is saying, okay, fine. I'm sorry. They will give admitted and give an affirmative defense, or they will deny it. An affirmative defense is saying, okay, fine, that's true. But an affirmative defense is, Tisa came and did a live, and the live caused somebody to be very, very sad. An affirmative defense is me saying, okay, yes, I admit on Article 9, I did start a live. However, My affirmative defense is it made nobody sad. There is no cause of action and it should be dismissed. Okay, let's get more into this. Despite petitioner's termination of Sheeler as her financial advisor due to Sheeler's malfeasance in relation to Wendy's accounts and Sheeler's improper conduct in relation to their professional relationship, Wendy continues to rely on Sheeler's advisement as support for its decision to deny petitioner access to her financial assets and statements. Now, here we get into the real meat of what their beef is, right? I'm getting excited. Now we're getting into the real meat of what their beef is. Let me just break this down if you guys don't feel like reading legalese, right? Lori was fired by Wendy's LLC. I'm going to use even Wendy's LLC that they're bringing up as Wendy. Lori was fired by due to malfeasance. That's gross negligence when dealing with something. Basically, you messed up. And improper conduct in terms of professional relationship. Now, listen, you don't need an excuse to fire someone. The point of the matter is she had already been let go. She'd already been let go. However, Wells Fargo chose to take the side of someone that had been fired or let go and freezing assets. Now, Wells Fargo has not admitted or denied that they actually stand by this thing that Lori Sheeler is of unsound mind. You have to realize that this is actually Wendy's team basically making accusations and see what fits. They're guessing that Wells Fargo did it because it's unsound mind, but they need Wells Fargo to officially either accept it and give it, agree and give an affirmative defense or deny it. However, part of the thing is, wait a second, this girl doesn't even work for us. We fired her and you guys are still taking her word for stuff. How is she relevant? How can she even speak? And if we fired her for improper conduct and gross malfeasance, which is basically gross neglect when handling people's money, why are you even taking her word for anything? Again, we must wait for Wells Fargo's answers to see how much of this they challenge. Everybody's treating these documents like it's the be-all, end-all. These are accusations that Wendy Williams's people are making in order to get the accounts unfrozen. We actually do need to see what Wells Fargo, but keep this in mind as we go on, because this already is a gross, it's a gross violation of fiduciary duties. The courts the courts take everything seriously, but they take fiduciary duty the most serious. Fiduciary is when you have a duty. When you have a duty that goes beyond a tort, you have a duty of trust to manage someone's money or something of value. It is fiduciary duty, and they are very, very strict about that. Okay, now here we go. Listen, here we go. So we just got into the meat, but it's getting good. As additional support for its decision to keep petitioners' accounts frozen, Wells Fargo, references its authority under the agreements to pause or reject instructions for a proposed transaction pending judicial or administrative remedies should they suspect financial exploitation, dementia, or undue influence. Again, we need to see what Wells Fargo answers to see what their official reason is for denying them. Now, it could be unsound mind. A lot of people are speculating. However, they also have financial exploitation, dementia, or undue influence. They could pick all the above. They could pick none above. We need to see what the bases are. Okay. However, and now we get into some meat. This is a legal clapback. However, the provision is inapplicable in this instance for several reasons. The provision, they're saying, listen, the provision can't be applied for these reasons. I know you're telling us, oh, I did it because of oughta, but it doesn't even apply. So what are you really doing, right? However, the provision does not apply for several reasons, including the fact that Wendy has not proposed a transaction for which respondent allegedly has the discretion to pause or reject. Now, this is where Wells Fargo actually played themselves. This is where Wells Fargo actually played themselves, because when you look at any corporate what is it? COIs, when their procedures or operations, right? The corporate procedures operations, there must be some type of light, right? Some type of fire that ignites a fuse. And then because A happened, B can happen. Wells Fargo is saying, listen, we did it because whenever there's a transaction, right? That whenever there's a proposed transaction and we think that there might be financial exploitation, dementia, or undue influence, whenever we think that might be, we have the right to freeze or pause those transactions, and all assets. Wendy's people shot back, but A leads to B and B leads to C. Where's the A? So you have a transaction. You think something scammy is going on. So now you can freeze it, or you can freeze, or you can pause. But where's the transaction that even started this? You can't bring this out of thin air, because if that's the case, they could just be bored one day and be like, let's go through Tisa's accounts and see what we're doing. Girls overdrawn again? Yeah, okay, it's the 5th of the month. She'll probably get an influx of cash around the 7th. I'm joking, right? But if they're just like, let's just be nosy and let's just freeze accounts for no reason, right? Jacqueline smells conservatorship. Thank you so much for the super chat. And you would not be wrong. We're about to get into that. I just want to walk everybody through so everybody actually has the real facts. Again, BuzzWorthyTv, Choke No Joke. And of course, you guys told me Chronicle Speaks. Let's give her a shout out to it. She's doing it. Apparently gave you guys comprehensive. However, and that's great, I just want to take you guys to the nitty gritty of the court documents, what I'm seeing, and then you can decide your own facts, all right? And if you've already seen these, shut up. This is for the people that haven't. If you've already seen this and you're smarter than the rest of the class, good for you. Go sit in the back until we're done. Cool? All right. So everybody that hasn't, come closer to the desk and let's get down to business. Okay. There we go. There we go. We're going to get into where her family is too. All right. If you've already seen it, if you're already the smartest person in the class, great. We are not looking for the smartest people. We are looking for the people that are trying to learn. Come closer. Okay. So they're saying, which is a really good legal argument, but in order for you to enact, there needs to be something that triggers your alarm so that you can freeze assets. Where is the act that triggered? Again, common sense might be, well, I saw her last week and she was looking a little loopy. I don't know. It was on some Weekend and Bernie stuff. Again, with anything legal, and especially with fiduciary duties and anything dealing with financial, it must be followed by the letter of the law. Okay? Now, especially for a break, you don't want the Security and Exchange Commissions sniffing around. Okay, so let's do this. Okay, where were we? Ooh, 13. And this is where the lawyer is getting in his bag, right? He literally is. I could just tell him. And even if, anytime you hear a lawyer start with, and even if, they're in their bag. They're in their bag. They're like, you wrong, you wrong, you wrong. And even if we believe the dumb stuff that you're telling us, you're still wrong. All right. So the lawyer is getting in the bag. Listen. Yeah, exactly. BuzzWorthyTv. Follow everyone, but it's important that we get the word out. This is more than just gossip. There's something in my bin. I don't know. I smell a scam coming on, right? Okay. Article 13. Sorry, I keep saying article. Paragraph 13. And even if the provision did apply, respondent is going beyond the scope of the authority granted by the provision because respondent is completely denying petitioner the ability to access or even view, whether online or otherwise, her financial assets or statements, which petitioner has requested for the purposes of ascertaining the current standing of her accounts, which is not a transaction as contemplated under the agreements. That lawyer was in their bag. What are they saying? They are saying, listen, even if we accept the BS you telling us as true, and that there is some magic transaction that triggered your scam meter, and that scam meter made you press pause on everything. How about the fact that you won't even let us see our online account statements or balances? That is beyond the scope of the agreement. So even if everything you're saying is true, you're still violating the scope of the agreement. And this must stop. We need a restraining order to restrain the bank from freezing our assets. The lawyer was in their bag, and they make some very, very good points. Now, I know what you guys are saying, but you know how it is in law. Nothing is cut or dry. We need to wait for Wells Fargo defense, but they go on to say even more because people have no shame. Okay. In other words, Wells Fargo's actions and the actions of its agents have impeded and unlawfully prevented petitioner access to her property. Now, let me tell y'all something. Anytime you see anyone saying that your actions have impeded or unlawfully prevented petitioner access to her property, I smell damages. I smell damages, and I see complaint, and I smell complaint to the Security and Exchange Commission. I hope to God Wells Fargo has dotted their I's and crossed their T's, because if I was one of these lawyers, I would be out for blood. I would be walking into that courtroom listening to Monster with the Nicki Minaj verse and gossip, be like, I smell a massacre. I would literally be listening to Monster by Kanye West featuring Nicki Minaj and Jay-Z, right? Talking about, and who else is on there? Rick Ross walking into the courtroom like we about to eat everybody up and literally lick the blood off the walls because this is about to be a massacre. Okay, now, paragraph 15. Although pre-dispute arbitration is required under the agreements, given the imminent and irreparable harm caused to Wendy by Wells Fargo's actions, Wendy seeks injunctive relief from this court pursuant to Article 63 of the New York Civil Procedures, preliminary enjoining and restraining the respondent from restraining Wells Fargo from denying Wendy access to her financial accounts, assets, and statements, pending a final binding decision by the arbitrator. Now, again, to me, this seems wholly reasonable. You cannot take away. Do you know how serious things have to be for you to deny? Narcos don't even get this type of thing. Do you know how serious something has to be for all accounts to be frozen off the name of someone that was actually fired? Not usually when they freeze accounts, it might be the bulk of accounts, but they look at like what your monthly bills are and they're like, okay, fine, you can have money for your monthly bills, but we're freezing everything else. They froze everything. Now, let's look at the legal standard, right? Listen, well, here's the thing. ECH Bunny said, I think the former manager may have been dipping into funds while Wendy was incapacitated, and she froze the accounts after learning her son now has power of attorney. Again, the one thing, and I want to speak on that. Thank you, EHC Bunny. If the son has power of attorney, for those of you guys that do not know, power of attorney is when somebody legally becomes you. They actually have more, once you give power of attorney over, they have more power over your affairs than even you do. The power within reason, right? Because there's different forms of power of attorney. But the son to have financial power of attorney, that means that if they think that Wendy is of unsound mind, right? If they respond back, well, we thought she was an unsound mind, it still doesn't pass the sniff test, because by having power of attorney, that means Wendy has agreed that she is also of unsound mind, and she has given all authority to her son. By all measures, her son, across all boards, everybody agrees, has all his faculties. So again, when you're saying that you're choosing to ignore the power of attorney in place, Wendy has elected her son to possess her body, and anything he says is better than what she can. And Wells Fargo is looking at her son. If they agree to what Wendy's lawyers are saying, are looking at her son and say, no, we have our doubts too, to your sound mind. Again, we do not know what is up with Wells Fargo. We do know something is very, very fishy in the fact that you can't even get access to what the amount is in the account. That's the weirdest part to me. And the fact that they are ignoring power of attorney, but Wendy's attorney is alleging that the reason they're avoiding it is, and again, the power of attorney, I heard that from Choke No Joke. It has not been verified that her son does have power of attorney, but Choke No Joke, when I was listening to his thing, he seemed to actually know people in Wendy's family and talked as if he actually suggested that he might get a sit down with Wendy. So he's getting his information from somewhere. Okay. Again, the power of attorney, but if he does have a power of attorney, it's very, very odd that they are even refusing to recognize a power of attorney. Okay, now let's see, listen, exactly. Her son can review books without her permission. He can even close accounts and move them to another bank. Exactly. Power of attorney, you give them all the power that you have. It's like literally you give them your life force and you give it to them. The only way that they could do this unsound mind thing, I can't stress enough, is if they prove also that her power of attorney, which is Kelvin Jr., right, does not have sound faculties. Okay, let's get into the legal standard. Darker Perspective said the fact that they're trying to supersede her son means they are covering some gross negligence. Now, we don't know if her son has power of attorney, but if he does, I would agree with what you're saying. And why fire Lori if she was so right? It's important to note that Wendy was the one that let Lori go, not the bank. So imagine you have like, I don't know, let's just say you have a maid, right? And you fire the maid. And then 2 weeks after you fire her, you find out that the maid literally is like, I don't even know what's the equivalent. But again, you have somebody that's an advisor. And then for whatever reason, you don't trust them. They're moving mad. So you fire them. And then 2 weeks later, your stuff is frozen because of things that the person you're fired is saying. It's weird. Okay, so let's look at the legal standard. Petitioner repeats and restates the allegations contained in the prior paragraphs of this petition as it was set forth in fully action. You must do that for the request for relief. If you guys don't know, with lawsuits, you need to prove, there's the one thing people forget about lawsuits, right? You need to prove that damage has been done to you. You need to be able to tell the court what relief you would like. That relief has to be something we can do on this earth. And then you need to prove, right? And then you need to have the request for relief, but then the courts have to decide that relief can be given. Let's just say you try to sue someone for stealing your hopes and dreams. Okay, they damaged you. They emotionally hurt you. They stole your hopes and dreams. So then the request for relief would be, okay, but what do you want us to do about it? That's the request for relief. You could say, I want my hopes and dreams back. I want them to give me this back. But then the court will say, okay, but there is no grounds for which relief can be granted. It's not enough that you identify a hurt. It's not enough that you tell the court what you want. The court has to be like, okay, but we're going to have to throw this out, because even though they did steal your hopes and dreams, and even though you want your hopes, there's no way that the court can give you back your hopes and dreams. So there is no relief. There is no standard for which relief can be granted, no grounds for which relief can be granted, and we're going to have to dismiss the lawsuit. You need those 4 things, right? 3 things. If it's a tort, you need a duty of care on top of that, and then to prove that your causation. Anyway, I don't want to get too much into that. My whole point is, if you are missing any of those things from most civil cases, the lawsuit will be thrown out. Doesn't matter how dirty somebody did you. You have to prove these things. Okay, so now, petitioner requests immediate preliminary injunction and a temporary restraining order. Preliminary enjoining and restraining responded. And this is respondent Wells Fargo and any of their agents, members, officers, employees, representatives, and anybody else on respondent's behalf. You have to go through that list, because don't think that somebody will be like, well, you said agent, but you didn't say representative. So you got to break it down and be like, anyone that even breathes your name. No, they're under this, right? On behalf of freezing all the petitioner's accounts, including but not limited to personal business, deferred compensation, investment accounts, and interfering with her right to access her financial assets or statements. So they basically just said, back off. We want to be restored and made whole. Now, this is actually important, paragraph 18. While ordinarily the function of a preliminary injunction is to preserve the status quo until a final determination upon the merits can be made, this is true. They usually do an injunction because they say, it's like, listen, let's just say that you want an injunction. You're suing someone saying that they cannot build a house next door to you and block your view. Now, you can go to court, and the court case could take 6 months up to a year to get, right? In that time, they built their house, and now you don't have a view. So now the courts in equity will say, well, we can't tear down their house because that wouldn't be fair to the person that built the house. So no relief can be granted, and we're going to dismiss the lawsuit. You go in for the injunction because you say, I need you to temporarily stop them until we find out whether they have the right to build. Because if you continue to let them go, it's going to make everything I said moot. It's going to throw out my case, and it's going to do a disservice to me. So the court can stop someone, because if they keep going, it'll damage you so much that it completely invalidates the case or irreparably harms you. So they're saying, okay, usually we stop this for this, but here's the thing. There's no question that in a proper case, the Supreme Court has power as a court of equity to grant a temporary injunction. This is true. Hold on, guys. Let's go to the next page. Which mandates specific conduct. In West Global Comms, Corp versus Miraki, what is this? Tiki Short? Right? And also, they're just citing preferences, right? In Zarulu, blah, 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 a 2010 Supreme Court New York City ruling, Chrysler Corp versus Fredo, they're citing precedents. You have to cite precedents to be like, it ruled here, here, and here. So, Your Honor, you should actually rule in this way too. Judges usually don't like breaking precedents, but it is what it is, right? Doesn't mean it doesn't happen. These precedents they're citing granted preliminary injunction directing defendant corporations to set aside and otherwise secure funds for payment of ratable dividends to one class of stock whenever payment is made to the other class. So they're showing, when you do precedents, you're never going to have a case that's just like your own case. So you're just basically piecing together different cases that make your point, right? Paragraph 19, to obtain a preliminary injunction, a petitioner must demonstrate a likelihood of success on the merits, irreparable harm in the absence of injunctive relief, and a balance of the equity of the petitioner's favor. Now they're citing Ruiz versus McCloney. The decision to grant or deny a preliminary injunction rests on the sound discretion of the court. Now they're telling the court, listen, you have discretion to do this. Other courts in New York have done it. This might seem like, oh, who cares? Like, everything would do, but you need to actually walk the court through. And this is what the other side does, why the judge should rule in your favor by citing precedents about other judges ruled in other people's favor. Okay. Now listen, here we go. Petitioner is likely to succeed based on the merits. Now you're getting into your bag about, listen, here's why we're going to win. To establish a likelihood of success on the merits, all that is required is prima facie case. A prima facie case is something so evident that you can tell on the face. You don't need to dig down. You can just tell on the face, right? By establishing a prima facie case showing of the rights of a relief requested. They cite more precedents, Malcolm versus whatever. Hey, Realm, thank you so much for the super sticker. I appreciate that. You guys, really quick, if you are enjoying this content, you know I'm always dragging. I'm always digging. But sometimes we do a more serious side because you know what I'm saying. And this site, we like to be facts-based. And you can believe what you want and have your own opinion. But baby, you're going to get the facts from me, or at least enough evidence for you to make up your own mind. There's 434 people in here. Please hit the like button. It really does help support and grow this live chat. Now let's move on. Moreover, it is well settled that a likelihood of success on the merits may be sufficiently established even where the facts are in dispute and evidence is inconclusive. This is Richmond versus Richmond. Again, what they're doing is citing case law, and they're actually citing cases which exemplify this case law. They're saying that in Richmond versus Richmond, they can make an injunction even based off the likelihood of success, even if they're not proving their case 100%. The fact that it's more likely to be than not is enough for them to rule on the injunction. Again, they reiterate, the mere existence of an issue of fact will not itself be grounds for a denial of the motion. Conclusive proof is not required. All right, Richmond versus Richmond, come through. Okay, so let's get to the next part. We're on paragraph 21. Declaratory judgment. The Supreme Court may render a declaratory judgment having the effect of a final judgment as to the right and other legal relations of the parties to a justiciable, I forgot how to read, controversy, whether or not further relief is or could be claimed. This is basically under New York civil procedure. Again, remember when I said that you must show the court that the court can grant relief. Now, it might be easy for the court to be like, I already gave you the facts. You decide if you can grant relief. But if you know anything about the court decision, you don't want to give a judge or the court that much power. What you want to do is actually spell out why this court can grant relief, and then spell out how they should grant relief. And then you let the court tell you, all right, slow down. Like, you asking for too much. This is what we're going to give you. Okay. Now, listen, here we go. The Supreme Court may render a declaratory judgment having the effect of a final judgment. Oh, we already did that. Sorry. To state paragraph 22, to state a cause of action for declaratory relief, a petitioner must show that there is a bona fide justicial controversy. I believe, I'm not the judge, but I believe they have met that burden of proof. They are saying that accounts were frozen. They do not believe that there is any reason why it should have been. And whatever reasons they were given, they feel like there is no factual basis for that, right? So they've met that burden. 2, and by met, again, once you get to court, you might have a jury. Jury decides matters of fact. The judges decides law. Unless you go for a bench trial, but who would go for a bench trial, honestly? Because of a bench trial, the judge decides law and fact. Fact is this: Tisa is a woman. You say, we don't think you're a natural born woman. I say, but I am, right? The jury then sees both of our arguments and they decide whether or not I'm a natural born woman. They now take that fact that the jury's decided and they pitch it over to the judge. And the judge says, given all these facts, I will apply the facts to the law. The law right now is what I am reading in paragraph 22. So the jury decides what is true or not, the facts. And then the judge takes the facts that the jury's decided and they apply it to the law. The law is very well written. And when you apply it, just plug the facts in. It's actually pretty easy, right? So the law, there must be a bona fide justiciable controversy. They think they've proven that. I think they have too. 2, these are different prongs. Prong number 2, between parties with adverse legal interests and a judgment there is adverse legal issues. They've proven that too. Wells Fargo saying, we need to freeze all your assets. They're saying, no, you don't. As a matter of fact, you shouldn't freeze any. So you have prong number 2 satisfied. Prong number 3, clarify or settle legal issues. Well, of course, that's why they're coming to court. That was the easiest one to rectify. And 4, prong number 4, initialize the controversy and offer relief from uncertainty. Yes. Now, those two were easily proven off the bat. That's why we go to court. But the other 2, I believe they've made their case. However, I can't stress enough, before we start going crazy, we need to listen to or look out for Wells Fargo's response so we can actually see what they admit or deny. Because when we get their admit or deny, that's when we'll be able to see what Wells Fargo is actually claiming, legally claiming. Okay. Now, where are we? They cite case law, Channels versus Maddox. All right, whatever. That was in the Second Department of 2010. So that's pretty solid case law. It's in the Second Department of New York State, and it was in 2010. That's about 12 years ago. Yeah, that's pretty good. That's law canon. All right. The petitioner must establish that the dispute is a real, definite, substantial, and sufficiently matured so to be ripe for judicial determination, and the declaratory judgment will have a direct and immediate effect upon the rights of the parties. This is a large city school district of Midway versus the city of Middleton. This is also Second Department, which is very, very heavy in 2012. You need to know that also when you cite precedents, do you guys care? I'm going to tell you anyway. When you set precedents, the more current a case is, or the more it has been decided, right, by a very heavy hitting jurisdiction, the heavier it is. Now, they are basically citing canon. This is what pretty much every lawyer cites to do. But again, you must do it because you don't want the judge to do it on their own, okay? In this case, now we're getting to the meat of it. Petitioner is likely to succeed in establishing her right to a declaratory judgment because there is a bona fide controversy between Wendy and Wells Fargo as to Wendy's right to access her financial assets and respondent's decision to deny her such access due to the adverse legal interest. So now they're applying their facts to case law, okay? Due to the adverse legal interest between Wendy and Wells Fargo regarding this matter, A judgment would settle the legal issue and finalize the controversy. Additionally, given the imminent and irreparable financial damage, because she can't pay any bills, she has no cash. Why did Wells Fargo think they could get away for this? I'm going to get through this and then we're going to talk, because honestly, why did they think they were going to get away with this? This is so... The banks, ever since they instituted anti-money laundering rules, which do some good, but also ever since there was like a scam culture and there were different things implemented and banks were given different tools to fight it, the banks have overreached, in my opinion, into the private sector. And I hear about stuff like this, not exactly like this, but stuff like this happening a lot. Okay. Anyway, where were we? Okay. Additionally, given the imminent and irreparable financial damage directly resulting from Wells Fargo's actions, the declaratory judgment will have a direct and immediate effect upon Wendy's rights to access her property. Thus, Wendy is likely to succeed on the merits for a declaratory judgment against the respondent. Now, you guys need to realize this. Getting an injunction, if you have a few bit of facts and you can prove you'll be irreparably harmed, getting an injunction is not that difficult, which is not to say it's easy, but it's not that difficult, because all you're saying is, can you press the pause button until we decide this? Now, the bank can come back and be like, no, it is going to do irreparable harm for us. And we like give you the assets, because what if you drain the account? And what if we're right? Then what's happening to Wendy's money? Usually what I think the judge is going to rule in this case, if the facts are super, super clear cut, the judge will say, I'm giving you this injunction for relief. Temporarily, we're going to unfreeze the accounts. However, the judge will probably put restrictions saying you can unfreeze the accounts, right? But only to the extent that we're going to set up an independent court-appointed trustee, so to speak, to go through what Wendy's expenses are every single month, all her expenses, even down if she gets like a Snickers and an orange Fanta from the store every morning, all her expenses. And we're going to let those expenses be paid out every single month until this is settled. Usually that's what the judge does, because it's somewhere in the middle. Okay, it's ridiculous to think that she can't have access to her funds. However, if by any chance, until this is actually solved and we have a doctor's medical thing, we don't want to give them carte blanche. Because what if Wells Fargo has a point and they drain all her assets? She's not of whatever they're accusing her to be. And now there's no, like, we've done a disservice to Wendy if what Wells Fargo's saying. So usually they go someplace in the middle, which is what I think, right? Which is what I think is going to be. Okay, so where are we? Let's just go. We're almost done. I'll get through this quickly, okay? The breach of fiduciary duty, this is the doozy. The elements of the cause of action to recover damages or breach of fiduciary duty are: one, the existence of a fiduciary relationship. We have that off the bat. They are a bank, that's fiduciary number one, and they signed up to be client services. They had the original contract. Also, even if there was no contract, you have a prima facie case for that. Our money is in your bank. It could not have gotten to your bank without a fiduciary relationship. By accepting our money, a fiduciary relationship is created, whether you agree to it or not. Boom. Misconduct by the defendant. This is what they're actually arguing, and this is what the jury or the judge, if it's a bench trial, is going to have to actually decide on, right? And three, damages directly caused by the defendant's misconduct. Now, this is what I was talking about when I said, and if you guys don't know, I'm reading through these documents real time with you, right? Because I was busy watching Korean dramas. But misconduct by the defendant and damages directly caused. Now, this is where we get into the money thing. This is when Wendy's attorneys are saying, you better be good and right with what you're saying, because guess what? You caused me damages directly from defendant's misconduct. Any deals I lost out on, any late fees I incurred, anything that literally has some type of tangible damages that relief can be granted by your actions, I get to sue you for. And I want that in my damages, okay? They cite a bunch of case law. Of course, the old Fitzpatrick House 3 versus Neighborhood Youth and Family Services. Again, second department literally rule. Well, I don't want to say it rules, but you guys don't want this. Anyway, let me get back on point. In the case, petitioner is likely to succeed on the merit of breach of fiduciary duty claims against respondent because Wendy will allege that the parties in fact have a fiduciary relationship. Again, that's the easiest one they won, of course. It's a prima facie. Respondent's misconduct in the breach of fiduciary duties includes, but it's not limited to, so that means you have to put that in just in case discovery literally finds more. So I'm including this, but I might find more in discovery. Sorry. Respondent's unlawful determination to freeze, withhold, or otherwise alters petitioner's access to her financial assets, directly resulting in financial damages from Wendy's inability to make timely bill payments. Boom! Didn't I call it? I'm sorry, y'all. I'm reading through this in real time, but the lawyer's in his bag. To make timely bill payments and incurring fees as a result. Accordingly, right, Wells Fargo engaged in conduct that is not in the best interest of Wendy. That is number one prima facie case for breach of fiduciary duty. Okay, again, they're bringing in Nassau Soda Fountain Equipment Corp, Mason, again, second department, 1986. Because this case is so old and it's from the second department, this is basically canon, right? Nobody can argue that this is not set precedents, okay? This is affirming a preliminary injunction where plaintiff demonstrated a likelihood of success on the merits by showing the defendants breached their fiduciary duty when they established and engaged in a business in direct competition with the plaintiff while they were still in plaintiff's employ. Thus, Wendy is likely to succeed on the merits of a breach of fiduciary duty claim. Yes, but the breach of fiduciary duty is weighed in on the fact that they can prove the other elements. Petitioner further submits the petitional harm faced by the petitioner if respondent is permitted to continue to interfere with her ability to access her financial assets far outweigh any potential harm to Wells Fargo and being precluded from such action during the pendency of arbitration. So they're trying to say that just because you give us access to funds does not mean that whatever you're trying to do and protect Wendy, like Wells Fargo claims they're trying to do, it doesn't mean that us getting access to the funds will not harm your case. So why not do an injunction? If this court does not enjoin respondent, enjoin means to bind, to enjoin them in a court order so they can't act, right? Wendy will be in default of several bill payments. Now here we get to the money, including her mortgages, her marital settlement payment. I don't think Wendy will care much about that. So that means, Kelvin and is that his wife now or mistress? Well, not mistress, girlfriend. Little big Kelvin and Sharina Hunter are mad as hell. They probably like, where is our spousal? Because all of her accounts are frozen. She can't even pay her alimony to Kelvin. Exactly, right? If y'all see Kelvin and Sharina trying to buy EBT cards outside the local supermarket, you know why. Sugar Mom and Wendy has dried up, Next. Okay, so she can't pay her mortgages. She can't pay her alimony. Ooh, and she can't even pay her employees. Now, here's the thing. I'm not a conspiracy theorist, but if you can't pay your employees, not many employees can afford to work for free. So if you can't pay your employees, if you are engaged in some type of nefarious, wouldn't the first thing, right? Maybe, sorry guys, I'm just trying to get this. Okay, maybe the one thing that you don't want to do, right? Maybe the one thing that you don't want to do is you want to make sure that the employees like don't represent her or get fired or like quit or whatever, and that makes it easier to do unsavory dealings. Now, I'm not saying Wells Fargo's engaged in that. I don't want this. I don't want a bank coming down on me. I'm just saying, if it was, it would be easier. Now let's go on into this. Wells Fargo's actions, if they're not enjoined, will threaten Wendy's financial viability. Wells Fargo continued interference in Wendy's ability to access her assets will not only result in Wendy's inability to support herself and her family, but also result in irreparable damages to her business and her brand. Yo, I smell damages for whatever they can think of. And I would be sitting there being like, they cost me a lollipop. Somebody told me that if I bought a lollipop in the next hour, they would give me 4. Charge them for those 4 lollipops. That's how petty you got to be. By contrast, Wells Fargo will not suffer any actual harm if it is prohibited from withholding or interfering with Wendy's assets and statements. Under these circumstances, where the equities overwhelmingly favor Wendy, preliminary injunction relief is necessary and appropriate. All right. If the court does not grant the requested relief, Wendy will continue to suffer imminent and irreparable harm because Wells Fargo is impeding Wendy's right to properly manage her personal finances and to make timely payments on billing accounts, which threatens her financial viability and the financial health and safety of her family. Additionally, without the court's intervention, Wells Fargo will be free to further damage Wendy and continue to interfere with Wendy's financial assets and property, which will threaten her ability to manage her ongoing business obligations. All right, they cite more case law. I'm not going to bore you with that because y'all don't care. Now, they go through the prongs about determining whether it is harm or irreparable is the availability of a legal damage remedy that will adequately compensate the applicant. I'm not going to go into that because that's just what I did with the prongs of you need to make a claim. It's not enough that someone hurt you. Not enough that someone took away something. You need to show that the court can give it back to you in some way, either financially, through an injunction, or through some type of seizing of assets. You need to prove that the court can make you whole. If you cannot prove that to the court, then they will throw out the lawsuit because they're literally like, what are we doing? Sorry, guys. Just need a lipstick touch up. I'm talking so much. My lips. Okay, let's get back to this. They said, in this case, enjoining Wells Fargo from freezing, withholding, and otherwise altering all of Wendy's financial accounts, assets, and property would be the most complete, efficient, and practical way of maintaining Wendy's rights. Keep in mind, this is just Wendy's side talking. We need to actually get Wells Fargo's side because anytime you hear one side talking, they're just like, listen, we're right, they're wrong. They should actually be banished from the earth. And how dare they? And strip them of their legal license and all their things. So that's, again, take this with a grain of salt, right? The alternative would be to permit Wells Fargo to continue to deny Wendy access to her financial assets and allow Wells Fargo to default on her financial obligations, resulting in petitioner's inability to pursue ongoing business endeavors and to force arbitration to attempt to measure petitioner's damage based on the amount of business that Wells Fargo could have secured and the number of billing payments that Wells Fargo could have kept current had she been permitted to access her assets. Thus, legal actions for damages is impractical and inefficient when compared to the equitable remedy of enjoining respondent from continuing to interfere in the first place. Now, this is interesting. They're actually alleging that Wells Fargo actually usually directly pays some of Wendy's bills. So if you're directly paying some of Wendy's bills, why would you freeze all assets? If you're directly paying some of Wendy's bills, that money doesn't even have to flow into our hands. You're the ones that pay it. It's like if you got your electric bill on auto pay. Why are you stopping my auto pay from going on? If you're accusing me of misappropriating funds, what my electricity bill got to do it? What does my legal stuff have to do for it? Pay them first. Also in the court of law, listen, I know people think the courts want to give out crazy amounts of money, but what they want to do is find the most efficient way to make someone whole. What they're saying is it doesn't make sense not to issue this injunction and then let's litigate and get to the end of litigation. Now Wells Fargo has to pay for all the damages we incurred, both damages we know of and damages that can come from you, like missing business opportunities. It could be astronomical. There's millions involved. On top of that, they're going to have to pay damages for attorney's fees, for all this stuff. Why go through all that when you can just literally enjoin them now? And that way, it will be the most cost-effective strategy to get us over the edge. That's what they're saying. There's a little bit more meat in here, guys. I just want to get to it. The equity, they say the balance of equities favors petitions. When you balance equities, that's what I was talking about. When you have to look, make sure that both sides by the injunction, neither side will be unnecessarily harmed by the injunction, right? The equities balance in favor of granting Wendy the requested relief, allowing Wendy to access her financial assets will allow Wendy to properly manage all ongoing personal and business financial obligations. Absent an injunction, Wendy's financial well-being is subject to imminent and irreparable harm by Wells Fargo's choices. Again, they're just reiterating, do you really want us to present you with the bill if you're wrong? Wells Fargo, however, would suffer no legally cognizable harm in being prevented from interfering with petitioner's ability to access her finances. In fact, Wells Fargo will only real opposition to Wendy having access to her funds is that Wendy will cease business with them by closing out her accounts, which Wendy has every right to do. Now, listen, let me just get into this. That is the real meat of it. Remember when I said with those assets thing, they want high net worth to have their money in the bank so they can basically go and play the stock market, so they can leverage it, so they can get married, so they can play around with your money. That's why banks give you interest, not because they're being nice people. The federal government, the Securities and Exchange Commission literally said, if you're going to literally play around with people's money while they're holding it in the bank, right? You have to give them some cut at the benefit you're making. You have to give them interest. Even that little 1, 2, 3, 8%, I don't know what percent you have to give them some type of compensation for using their money, their money to basically make bets on. All right, I'm simplifying this a lot. If there's somebody that's actually in finance, great, but you guys know what I'm saying, right? They're saying that the only reason you guys are even not allowing this is because you don't want Wendy to close her account. Because when they fired Lori, I'm willing to guess, again, that they fired her and they were unhappy with what she was doing and they were planning on closing they were planning on closing the account at Wells Fargo and taking it to a different bank. And Wells Fargo wants to keep that money. Now, I still think it's weird what Lori did. So I think it's weird what Lori did. And again, EHC Bunny, you had a good theory. You don't know if it's true. This is all speculation. That it sounds like somebody is hiding something they did impropriety, because it's just so odd to me that you will not even let them see what their account balances are. Why is that? Is money missing? What is the point? Do you see what I'm saying? Y'all see what I'm saying? Okay. Now, under the circumstances, this is paragraph 33, under these circumstances, where there is no evidence that injunctive relief would impose a hardship on Wells Fargo and where the equities overwhelmingly favor Wendy, a preliminary injunction relief is necessary and appropriate. They cite canon law, right? Which is US, e.g., US ice cream, they're just, e.g. at all, right? About preliminary injunction prohibiting interference with shipments by suppliers to painters. It doesn't matter, it's a shipping thing. They're citing more canon. All their canon is from the second department. This is all New York Supreme Court judgments. It weighs very heavily, right? More canon case law. Now, let's move on. Almost to the end, guys, and then I'm going to go through the thing. We're going to take questions. Paragraph 34. Accordingly, this court should grant Wendy's application for preliminary enjoining and restraining Wells Fargo if any of their agents, members, officers, employees represented, me and you, your sister and your mother too. That's basically what they're saying. Anyone from your set, anybody that reps Wells Fargo, best not look at Wendy's thing. That's basically what they're saying, right? Including but not limited to petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts, and interfering with her right to access her financial assets and statements pending a final binding decision by arbitrator, and for such other relief this court deems just and proper. Now, one of the reasons they keep bringing up an arbitrator, usually when you sign a banking agreement, and with a lot of contracts, they literally say that if you are going to court for these things, it must go to arbitration. Arbitration is supposed to be quicker, easier, and cheaper. That's why companies, and also usually with arbitration, well, always with arbitration, there's no jury. Juries are the ones that usually look at the bad guy and do a Cardi B, right, to Wells Fargo's Tasha K and award damages out the nose. This is New York. I think it's Manhattan. I have heard that the Brooklyn, New York, if you can get a case in Brooklyn, the juries are very, very sympathetic to workers, employee compensation, stuff like that. I don't know so much about Manhattan, but you know, with the Brooklyn ones, they are. Now, I will say this, right? The arbitration, the one, sorry, I just got an email from CB2. I'm addicted to that store. Literally, I'm trying to, like, my whole house is going to look like a spaceship by the end of it, right? Okay, but back to point. Sorry, I just got an email for CB2. I was like, ooh, new things for spring. Where was I? Oh, okay. Oh, arbitration. If you ever have to go to arbitration, don't let, oh, thank you so much, Miss Innabug. Thank you, Miss Innabug. I appreciate the super chat. If you ever move to arbitration, I will just say, do not let the opposing side pick the arbitrator. Because the last thing you want, even though arbitrators are supposed to be fair, and most of they are, but when they work with an arbitrator that they're used to working with, sometimes the arbitrator, because they tried past cases with them, looks at them as a little bit too honest. Do you know what I'm saying? It's kind of like they're just like, yeah, I'll be fair and impartial. But I know Tisa, and I've worked with Tisa plenty of times, and Tisa has always been pretty honest. So now that Tisa's coming with this arbitration against YouTube, whatever Tisa's accusing of, there's a chance I might be a little bit more lenient with Tisa because Tisa has a reputation for honesty with me. Always fight them for whatever arbitrator they want to take. You might have to go to arbitration and mediation. Always fight to make sure that you pick out the mediator or the arbitrator. That's just a little hint. Okay. So anyway, let's go. Now, wherefore, the reason for the foregoing petitioner, Wendy Hunter, here be request that this court enter order. This is them demanding the relief for which the court can, relief for that can be granted by the court. Enjoin and restrain Wells Fargo, any of their agents, members, officers, employees, representatives, and anyone else from acting on respondents' behalf, from freezing all of Wendy's accounts, including but not limited to personal deferred, compensation, investment accounts, and interfering with her right to access financial assets and statement, pending a final binding decision by an arbitrator. All right, so they've agreed to arbitration, but they say you need to give us our money before then. B, enjoining respondent and any of their agents, members, officers, right? Anyone that breathes Wells Fargo, that reps their set. Behalf from freezing, withholding, and otherwise altering. Ooh, that's interesting language. Altering any and all assets that are currently identifiable as accounts and policies which contain funds that were removed and or withheld from petitioner's own personal business accounts and all other funds, whether known or unknown at this time, deposited into a bank and deferred compensation accounts, resulting in petitioner's inability to access her financial. Now, this is interesting. The reason I said, ooh, like I never saw this before is because I'm actually reading through this with real time with you guys, okay? Wendy's lawyers are literally on the same trail that EHC Bunny is, and a lot of you guys are. What Wells Fargo is doing is so odd, and not letting them see what the account balance is so odd and such an overstep of even their own rules that they even said, right? Freezing, withholding, or otherwise altering. Altering means moving money around, changing things, doing whatever. Because here's the thing, if somebody took that money out and then they put it back in, the crime's already been committed. They can already get damages from that. Doesn't matter, they put the money back. So altering would mean taking stuff out, moving stuff around, or if there is impropriety, putting stuff back in, right? Or altering any and all assets that are currently identified as accounts and policy, which contain funds that were removed and or withheld from petitioner's own personal and business accounts. So they're even saying, y'all might be doing something shady. So if they are, we're going to put this blanket statement for the injunction, because if you violate the injunction, first of all, you breach the fiduciary duty. But even if you violate the injunction, what is it called? I forget, where treble damages. When you show such gross negligence, and when you already lied and you broke fiduciary, but then you get an injunction and you even break that, that opens you up in New York State to treble damages. Treble damages is where you take the amount of damages, because all damages on certain types of cases are capped, right? And you literally treble it. You literally triple it, right? So basically you go deep for somebody's pockets. So let's just say the cap on these type of damages, let's just say, is 3 million, right? The actual damages, fine. But I mean, let's just say the punitive damages are capped out in New York State by law. You can only get 3 million in punitive in addition to what your actual damages are. If you hit that gross negligence, I believe it triggers treble, and now treble, Treble, and now all damages can be tripled. So now you're looking at a cap of 9 million. Okay. Now, let's see. Where are we at? Okay, one more. Hold on. We're almost there. Okay, they're also trying to forbid administrators, managers, everything else from removing, transferring, surrendering, selling, cashing in, or hypothecating and otherwise altering or moving any or all assets held in Wendy's name on her behalf and in the name of third parties, all bank accounts, credit accounts, deferred compensation, basically everything, every penny she has in there. And they also said known or unknown, because they think they know where Wendy's accounts are, but there might be other accounts that Wells Fargo knows about, but Wendy doesn't. In discovery, if this does go to arbitration, they're going to have to make notice. And again, if they lie and they hide, they will be severely punished on that. Again, it sounds like Wendy Williams' lawyer is like, yeah, something's going on here. And whatever it is, we think you guys are up to no good. They want to enjoy and prohibit Wells Fargo and their agents from acting in any capacity which might affect the assets and or operation of Wendy's and any other assets to which Wells Fargo might have access to, where such assets have already and might continue to interfere with the operation of Wendy's personal and business endeavors and financial obligations. So they're saying, guess what? You guys think that you might have done something by keeping all Wendy's money in that bank and doing this stuff, but guess what? We're taking away your ability to even access those funds and use it for whatever you want it. So any buying, any selling, any trading, anything, you guys got to stop it too. You can't make a penny off of our money that's in the bank. That's it. The only thing you can do is put our interest in our account. That's it, right? They also want directing that respondent reopen, and this is, of course, any frozen accounts or assets and grant access to any accompanying statements. They want to see those statements because they feel like something's going on. Currently identify as accounts and or policies which contain funds that are removed and are withheld from petitioner's accounts within 48 hours of the date of the order. This is an emergency thing. I think it was submitted on Friday. The judge, because it is emergency, I'm willing to guess is going to rule on this. Well, Wells Fargo has to reply. I think because it's emergency, correct me if I'm wrong, they get 3 days in an emergency petition, usually 10 days, but I think 3 days in an emergency petition. To respond if they want, but even if they don't respond, the judge is going to make, because it is an emergency, the judge is going to make a ruling probably Monday or Tuesday at the absolute latest Wednesday, I'm guessing. Okay, so make sure you subscribe and set your reminders. Please make sure you subscribe and set your reminders, because you guys, I'm going to be following this. If you like my coverage of the Tasha K case and you like what I'm talking about, make sure you subscribe and set your notifications so you can be updated when I get. Also, hit the like button if you can. There's 476 people. And if you guys are new to my channel, hey, Lila Adams, thank you so much for becoming a member of the Tattle Tell family. I appreciate that, Lila. If you do that, just know that this is some of the more serious, but if you guys know, my Tattle Tells will tell you I like to be messy. So sometimes we're going through legal canon. Sometimes we're getting messy as all hell. Sometimes we're speculating, and sometimes usually we're just laughing at how ridiculous the news is. So if you like to laugh and be informed, make sure you hit that subscribe, like, and turn on your notifications, okay? And shout out to BuzzWorthyTv. They covered the link to the video that set them off. They also sent me these documents. Thank you so much, BuzzWorthyTv, for actually sharing and caring. Go on and not just subscribe to them, but hit that link and watch the video. It's super informative. We also have Choke No Joke. He did it too. I watched his video you can, the video is like an hour and 12 minutes, but at 28 minutes is where he starts talking about the case and what his theory is and what's going on. And to me, it sounds like he knows people in Wendy's camp. So he gives like a little bit different perspective from the family's point of view. Okay. And he does say that he might actually do a sit down with Wendy. We don't know if that's going to happen, but go ahead. And also, you guys said Chronicle Speak has also been covering it. So please go ahead and support Chronicle Speaks too. Okay. Where was I? They want this done within 48 hours. And joining in subparagraph F, enjoining and prohibiting respondent and or their agents for acting in any capacity which might affect Wendy's ability to close and or liquidate any financial assets with Wells Fargo. They're also trying to say that you can do this injunction, but we're closing all our accounts with Wells Fargo. Now, this is where I was like, you guys tried it, because it's not the fact that they don't have the right. It's just the fact that when you talk about doing irreparable harm to the plaintiff, if they can prove that there's some sort of malfeasance with Wendy's side, then they can say, well, maybe it's not Wendy's will for her to cease doing business with Wells Fargo. So I don't know if the judge will go quite so far as to say, yeah, and you can pull the money out, because then it's like, what is this case really about? Do you see what I'm saying? But we'll see. Including but not limiting to bank accounts, deferred compensation, and life insurance policies. Again, in my opinion, I think this all goes back to money. I think that girl Lori, because you do get commission off of that for whatever reason. I don't know why she put a freeze on it, but I think it's because she was fired. They were going to move everything. And again, it seems real suspect. Then subparagraph G, granting such or other and further relief as the court deems just and proper. You always want to throw that in. All right, guys. Woo! We have gotten through their pray for relief. I got to be honest with you. It sounds like they satisfied a lot of the different elements, a lot of the different factors of the law and case law. It does. The only thing that would stop this is if Wells Fargo can show that there's either some type of financial untoward things, if there is some type of mental incapacity, or if there is some type of just gross impropriety. But in order to do that, you would need a judge to come. I'm not judge. You would need a doctor to come in and speak to her mental health. She would have to be evaluated by, of course, her doctors. You can request medical records. And also, if the medical records don't say what it wants, Wells Fargo might be able to ask that Wendy be evaluated by an independent medical professional. Now, if I was Wendy's team, I would already get my team to do a medical evaluation, because one thing I do know about courts, well, I don't know it, but one thing you can say about judges in courts, once there is a doctor that goes on record saying something, there's something about the medical professional, another doctor is not going to argue. They'll just be like, I mean, maybe that's what they said. I don't know. You guys decide for yourself. Doctors don't like arguing with each other over who's right. There's something about the doctor profession. I'm not saying it's right or wrong. They just don't like arguing. Okay. So if I was Wendy's team, I would 100% have an independent medical evaluation waiting to turn in, waiting. Like, and Your Honor, here's an independent medical evaluation. But when the Wells Fargo is going to have to prove that. However, to Wendy team's point, it takes time to prove this. And you cannot freeze all our assets that will have us with the mortgage payments, with the alimony. You know, Calvin is like, please, please, please let this prayer for relief be answered. Please. You know, Calvin is like, Sharina, let's hold hands. Please, our Lord in alimony, please bless us with Wendy's daily bread and hope, right, with what I opened, and hope that she can bless us another month and pay our living expenses, right? Yeah. So listen, let's go through these comments really quick. Oh, an hour and I've been talking for an hour and 20 minutes. You guys, what do you think? Hey, Rim, thank you so much. What do you think? Exactly, Kathy. Doctors and lawyers do not. Okay. Anyway, so where are we at? Any questions? Yes, Wells Fargo did a lot of shady stuff back in the day with mortgages and caused a lot of people to go through foreclosures. This is true too. Wells Fargo has a very sordid past with the way they handled finances. They actually had to pay billions in, well, not billions, but hundreds of millions, bordering on billions in a settlement. Again, maybe things have changed. Maybe they've gotten their account straight, but it is what it is. Darker Perspective said that these bastards ask her to be evaluated. This will be a problem for everyone. This case will set precedents in case law. Wells Fargo must be stopped. If allowed to exceed, our money isn't safe. I mean, I see what you're saying, but I do believe that Wendy's prayer for injunction can actually be granted very, very easily. Any other questions? No? Who would put their money in a bank and have a bank force you to get access to your own money? That's true. Hey, CYOs, what's going on? These are all good questions. Darker Perspective, doctors are like cops. Again, I have a lot of friends who are doctors, and I have a lot of respect for their profession. But I do agree, Darker Perspective, the way you say that the same way there are bad apples, there are bad apples in every profession, but the same way that the police arm protect their own, right, is the same way that it protect their own is the same way that doctors protect their own and lawyers. Most professional associations actually protect their own. Do you see what I'm saying? And they protect their bad actors sometimes. So keep that in mind. Listen, Wells Fargo has a new investigation opened last year. Did they really? I did not know that. Thank you so much. Yeah, Bank of America and Countrywide. You could tell. Yes, yeah, Sandra, I'd love to hear it. Okay. Meanwhile, you're waiting for the other stimulus check. I'm gonna hurt you, Amber. Listen, like the video and show some love. Yes, get a mortgage loan from a credit union, I guess. Let's see. So anyway, I hope that helped you guys investigate a little bit more and understand what's actually being going on. I hope this was super amusing to you guys. And also, I'm going to keep my eye on the dockets to make sure you hit that like and subscribe button, or at the very least, turn your notifications on. So when this comes, it can be hot off the presses. I'm also going to be doing like little updates in like sort of videos, and then doing these big long lives to go over the court documents so we actually understand. Again, everybody reports, everybody does, but you know me, I like to lighthearted, but then I also like to take deep dives into stuff, right? I like to take deep dives into stuff. That's why we are doing this. Listen, yep, they also got charging more for loans given to people of color. Oh, thank you so much, Mika Boo. Hey, Mika Boo. Thank you so much, right? Amika Boo, you are always on it as usual. Have you heard of Kim putting Kanye on a 5150 hold? What do you think about that? Kim can't put Kanye on 5150 hold. I do know in the state of California, the only one that can put you, unless they have power of attorney over you, the only one that can put you on a 5150 hold is yourself. And as soon as you feel deemed to walk out of that building, you can. So Kim can't put Kanye on a 5150 hold because she doesn't have power of attorney over him. So even if she tried and said he was a danger to himself, a 5150 hold, you must consent to it. Okay. Hey, me, thank you so much for the super chat. I agree. Let's see. The bank may have a court order, but they're not allowed to tell her why. I don't agree with that. I believe the fiduciary duty, if they are withholding your funds, they must tell you why that court order is. They actually have to tell. For somebody to get a court order for you, if I'm wrong, they have to notify you that legal action. I cannot take legal action against EC Bunny to take her house without notifying her that I feel like I have a claim to that house and I feel like she owes me that house. So I understand what people are saying about like secret things, but when people are actually seizing your assets, you must be notified as to the reason why. And if it is a court order, you must be notified why that court order is. You know what I'm saying? Okay. All right, you guys. So anyway, listen. Oh, thank you, Nerva. Okay, listen. In the state of California, a psychologist and a psychiatrist can place you in a 51 hold, but they need your consent. They do. And as soon as you say you want to be released, they have to let you go. 5150 holds are like something complete. Anyway, it doesn't matter. You guys, thank you so much for joining. I appreciate all of you. Thank you for rocking with you. Just make sure you like and subscribe. And I will see you guys tomorrow because I'm going to be watching this. Also, you guys, I posted a whole bunch of videos. They're super funny and super amusing. Make sure you go and carry them out because if you are interested in the Kim and Kanye stuff, ooh, baby, it's juicy. Fun fact, one of Kim's lawyers and business managers are also the same person that helped establish Britney's conservatorship. Fun fact. All right, guys, I got to go. Talk to you later. Okay. Talk to you guys later. Bye.